Hello, everyone, and welcome back to the Rebuttal podcast, where we break down case law, calamity, and of course, chaos in the legal field. I am your host, Reb Maisel, soon to be a formally published author. Incredible, amazing, gorgeous. Pre-order my book at the link in the description in the show notes if you'd like. The release date is right now, November 11th, 11/11. It's giving good luck. I mean, we are blessed. We are divinely protected and assuredly blessed. Okay. I cannot wait for you guys to get your hands on it. With that being said, today I was thinking about, not really thinking, but this now is going to take a complete left turn in terms of topics. I get so many DMs from people asking me to marry them, not as in be the person ordained, right? And say, okay, you may now kiss the bride. Not so much that verb, the other verb, as in me saying I do with a veil over my face, which is flattering, sure. More flattering when it's women, definitely. But I do get a lot of that from men, just a cold open, we should have an arranged marriage in 10 years and see where it takes us. Weird why they need to wait the decade. Maybe they need to tie up some loose ends, finish completing a prison sentence, perhaps graduate from college. I've gotten those pretty steadily over the last 5 years. Okay, nothing new, nothing news, but recent influx in new followers, and that thus means new marriage proposals. On one knee, rings purchased, I would hope, right? And of course, before I decline, I say, we'll send a pic, right? I want to see what I'm missing. And typically, it's nothing that I don't want to miss. So that's fantastic and good. Good for me and good for my boyfriend, for sure. I have told you guys this, but a reminder, I could never do family law full-time practicing as a family law attorney or divorce attorney. I joke that I will be every awful man's ex-wife's divorce attorney and will take everything and the dog and the kids and the boat and the yacht and the car, okay? Cars, because that's hilarious and that's funny and that really gets them riled. But being a family law attorney requires so much ability to not care that every single person involved is a diabolical person. Your client, the partner, every family member involved, friend, everybody. And yes, that happens in every field, right? In civil law, of course that happens. And in criminal work, that happens. But specifically with the brand of it that happens in family law, I couldn't do, because the millisecond that children are involved and are being used and turned against the other parent for like petty bullshit and petty spite between just two people who used to like each other maybe and you know, had intercourse and had kids and got married and now despise each other simply because they hate each other. The children are the only ones really suffering the most. Diabolical petty shit. That is the type of stuff that I could never tolerate. I can tolerate people just being awful and like being petty and being terrible because it's like, who, you know what I mean? Like whatever, you can ruin your own life. I don't really care. But I would have a hard time closing my mouth. I would have an extremely difficult time using, very much right, lawyers are customer service people. We absolutely have to use some customer service savvy. We can't just blurt out everything that comes to our mind when it comes to our clients' decisions. Of course, we are, of course, counseled to advise them, but we can't force anybody to do anything, right? Like if they want to break the law, like, listen, okay, everything's privilege that you tell me, but all I can tell you is what could possibly be a consequence of what you're trying to do. When it comes to child custody and shit like that, I would have no customer service face. I would have no bedside manner. I would tell them I'd be like, go fuck yourself. I know that's really mean, but like the shit that I have heard from family law attorneys of what people do to their children just to get their lick back because their ex is with a girl they went to high school with. I mean, I would violently roll my eyes and have no patience. I would have no patience. I would have no patience for it, especially if my client were like, No, I don't want you to accept this super agreeable, reasonable custody agreement. I just want to piss him off. So we're going to make this longer and force the kids to have to deal with this shit longer. Like, I have no patience. So with that being said, just thoughts, you know what I mean? Big thoughts that I've been thinking. I have examples for you of cases that I feel would absolutely have been maybe maybe a last straw for me if I were a family law attorney. Others that I'll tell you about, I think would even have given me a reason to potentially try it out. Okay? For the bit. I love committing to a bit. Actually, let's rephrase. I love doing a trial run with a bit. That is one thing that I will say. I cannot be scammed, but I will run to a scheme. I love a scheme, okay? A scheme, if you will. I can't be scammed. I can't, these robocallers, the text messages, you have unpaid tolls. I cannot be scammed, okay? That one lady who wrote an article, an op-ed in like the New York Times or something, or the Atlantic saying, hey, I was scammed out of $25,000 because someone texted me and called me and told me, basically convinced me to leave a duffel bag full of cash outside of a grocery store. And this could happen to you too. Who? Me? There is no we in this scenario, baby. You. That happened to you. Don't drag me into that. That would never happen to me. And probably most people with a head on their shoulders. Yeah, a lot of people can be scammed if it's elder abuse, especially if they're taking advantage. This lady was like my fucking age, okay? And she's being all condescending, like, can you believe it? It's a pandemic. No, it's a eudemic. It's a eudemic. And they scored big and they should be able to keep it because that's fucking crazy, okay? I cannot be scammed like that. No, thank you. Delete and block, delete and block, delete and block. I don't care about threats, baby. Until a warrant is in my mail, unless the police are at my door, like, please, okay? Get like, no, thank you, no gracias, all right? But I love a scheme. I love a scheme. And I love hearing about someone else's plans to do schemes and having the opportunity to observe. I won't get into that too much. It's nothing illegal. Don't stress and start predicting, but you know what I'm saying, okay? Like a friend who's planning to show up at a bar because she knows her ex is going to be there and the ex was just a nightmare, misogynistic, horrific, loserville, jobless, awful, unlikable. Was she held hostage the whole time? Man, I will absolutely tag along. I will pay for the Uber even. That is a scheme that I want to be involved in, okay? I love a confrontation that can only end properly for a woman. Okay. Two schemes, two schemes that I would have very much thoroughly enjoyed to be involved in, if only for the anecdote and the story and the ability to say, do you guys want to hear something crazy? Even though shit's privileged, but like, I'll talk about it with the other attorneys in the firm. Okay. Are to be involved in two of these cases that I'm about to tell you about. Okay. One involves Sasquatch. The other involves Applebee's. Those are my synopses for you, okay? The first case, though, is coming out of Ontario, Canada. Pause really quick. We ran out of time to talk about the Sasquatch and Applebee's cases. Those will be in the next episode. I promise they are worth it, but this one, indeed, is a doozy. You will not be disappointed. Don't hate me. Don't yell at me. We are starting with a good one, I promise. Marriage is not supposed to be that hard. You are supposed to enjoy your partner, have camaraderie with your partner, go through hard times with your partner. But when people who really should never have been together stay together for the hate of the game, really, the only thing that results is usually children in hell wishing their parents would split up, and two people who are just miserable. But obviously, there are a lot of factors that can push people together and keep them together. There are also a lot of factors, as the married community will probably yell and scream at me via email very shortly. is, yeah, marriage can get hard for several different reasons, but the difference is that it's not always hard. A good marriage is not always hard. It should not be pulling teeth for you to decide to want to make another person happy or to arrange your life around another person because you chose to do that. You chose to do it ongoing actively. And yeah, maybe marriage is hard, especially when people change and you fall out of love. I'm talking about like people who are like second year marriage hitting us with an Instagram caption 8 paragraphs long. They got married, mind you, after 30 seconds of fucking dating, right? And they're fresh out of 23-year-old birthday parties saying, this has been all of the challenges that have been thrown our way, the most difficult, all of the fights, all of the stuff we have said and can never take back. All of it's worth it for you and I to ever long lasting be together in this life and beyond. Baby, be in the beyond. If you do make it through this life, y'all are going to be so fucking far away from each other. Okay. One of y'all is going to be a rhinoceros in fucking Africa. The other one of you is going to be a flea, a harmless little flea in the Amazon. Trust, okay? You guys were not meant to star-crossed lovers. Those stars slammed into each other and exploded in a negative fashion. It was not pretty, gorgeous firework. It was the destruction of a civilization, of your soul, okay? That is what certain marriages, some marriages, look like to everyone else, and indeed, in fact, are when you get into the nitty-gritty, okay? The knitter-gritter, as I say. I believe that when you really are meant to be together, okay, because you are indeed, newsflash, supposed to like your boyfriend, you're supposed to like your fiance, you're supposed to like your husband. I know, crazy, right? And your wife, okay, and your girlfriend, anyone, all right? And your he, him, your they thems. You're supposed to like them. You're supposed to enjoy them as people inherently to their core. Marriage, I fear, maybe I'm going to be screamed at for this. People choose their siblings all the time. They choose families all the time, right? Not by blood, but by choice. You are choosing a family when you have a partner. And just because our society has ingrained in us so hard with the jokes and the ball and chain stuff, it's like classic boomer guy who's married with kids who don't really like him humor to be like, oh, I hate my wife. Like every punchline is just, my wife fucking sucks. Ha ha ha. You know what I mean? Like how to keep her happy so that she stays the fuck away from you. How to keep her out of your man cave. Like that. You are roommates with someone who is more, as a woman, you are in that moment roommates with someone who is more likely to kill you than any other category of man or person on the planet. Fun fact. Crazy, right? Yeah, because your husband, your intimate partner, is more likely to kill you than a random stranger going boo in the street. So marriage, of course, the good ones, the great ones stay together. I am a firm believer that if a marriage is not working, the whole sunk cost fallacy that people have about, oh, well, I've already spent 5 years, I've already wasted, quote unquote, 7 years, or I've already spent 10 years or whatever. Like they think that because so much time has already been put into something that they are losing something by getting the fuck out. You aren't losing a damn thing. That is a fallacy, okay? You can start today on making your life better, both of your lives better, on getting out, on choosing happiness, because you only get one life. And in this context of maybe, hopefully, an 80-year life, maybe a 70-year life, maybe some people are on a shorter timeline and we don't even know it, okay? 10 years versus 20, it starts looking like a lot. Big fucking difference, okay? Get out if it's not working. Get out if it's not working. And you know what I mean by that. Not at the first jump, okay? Not on the first fight or the first drama or the first hardship, but being together should be a relief. You should be relieved that this person is the one who is your partner. It should not be like you need to seek out every other person in form of comfort other than your partner when shit hits the fan. If that completely opens you up and causes some breakups, then I've done my job. Because I just want to see people happy and not chained to each other with invisible handcuffs. But people stay together because there's abuse and financial abuse and a domestic violence. 100% I'm not talking about that. You know that I'm not. I'm talking about people who willingly do it and there's not like abuse allegations, okay? Or abuse happening. Oh gosh, people are going to yell at me, huh? But I'm not, I'm not saying that. Whataboutism. I'm not talking about people who are being financially abused, emotionally manipulated, physically abused, who have children involved where it would be unsafe for them to leave, where they don't have a job and they're being financially supported by that person and they don't have a support system because the person forced them to move to a different place. I mean, there are so many stories of this and the women who are able to get out are heroes, and sometimes it does take several years. Absolutely. But my message to them is not you're lame or it's a character flaw for you to not have been able to get out. My message to you is no matter how long it takes you, you always deserve better. You will always deserve better, no matter what. It is not a moral failing that you ended up in a relationship that is harmful to you or your children. Yes, maybe you made some mistakes along the way. If you are with a person who's going to continuously remind you of those and all of the times you forgave them or all the times XYZ, that is going to really be hard on you. That's going to weigh on you. Doesn't matter. At every single moment you wake up, you always deserve more. Now, in 10 years, in 5 years, in 50. Okay? I'll leave you with that. But I'm not leaving you with that because we're going to keep going. Why, you may ask? Oh, because we're going to talk about some marriages that absolutely should have tanked. Should have for sure tanked. Shit was hitting the fucking fan because sometimes you can marry the love of your life and other times you can marry a nightmare, Satan incarnated. Or maybe both of you are just regular people who aren't compatible even a little bit at all. And for whatever reason, you came together for the opposite of a joint slay. I like to call it a joint dismay, a joint Jesus Christ, a joint, oh my God, can we have our wedding gift back? You get the picture. This case is a doozy, and I say that often, but not lightly. This case is a culmination of two formerly married people's efforts to make both of their lives a living hell. And you would think that being married to one another was hell enough, right? The hell that was due and the hell that was paid, deposited, all right? Absolutely, card was not declined. They both went through it. Went through the fiery depths. But the difference here is often in a post-breakup situation when indeed both parties have moved on to new relationships that are apparently doing well, you need to start a fire for the other person that is of your own doing, even if it means both of you are aflame, right? Because really, how great is it really feeling when you are getting your lick back, when you are being petty, okay, in the aftermath of the hell you walked through, and both of you are taking L's after L's and racking up legal fees to the gods, okay, to the heavens, praise be, and the judge is so exhausted and aghast, and a family law judge, mind you, to make a family law judge this exhausted and aghast, you have to do some absolutely outlandish, absurd things, all right? Because they've seen it all. I know a judge who saw a man, a gentleman, an ungentleman, throw his own fecal matter at a cousin in court because the cousin said that he had just fallen off the wagon, had been drinking again, and therefore it supported the former wives, the ex-wives, need motion to restructure their custody agreement, okay? Fecal matter in the courtroom. And the judge apparently didn't even, I mean, I saw the footage, it was a stake, of course, right? That shit was apparently it was on camera. I don't know why. Family court, you think it wouldn't be, but I swear to God there was footage. And they didn't, you didn't even flinch. Because mind you too, any man who's throwing his fecal matter in a courtroom for whatever fucking reason is never going to have a good arm. Riddle me that. Write that one down. Okay, if you're wondering, hey Reb, I really wanted to get some insider tip and scoop-diddly-oop today about how I can game the system. All right, the legal system, especially in a family courtroom setting. I am simply here to tell you, not about how to file paperwork, not about how to testify, not about how to act in court, the decorum you are supposed to adhere to. I am here to tell you that if you see anybody take out something fecal matter shaped in a courtroom and wind up, it is going left, right, and nothing straight. Whoever they're looking at, assume 8 people to the left are going to be hit, are going to be in the strike zone. Okay? That splash zone, like SeaWorld, if it is the other type of matter that isn't fecal. You get it. And if you're grossed out and you're gagging and you're listening to this on your commute, how do you think we fucking felt? All right? It was 8 in the fucking morning when that happened, when that occurred. Was I part of it? God bless, I wasn't. Did I hear about it from everyone involved for the next 3 years of my life? Abso-fucking-lutely. Abso-fucking-lutely. Okay? All I'm saying is I've never seen a monkey, one of those chimpanzees, okay, caught on camera throwing their dung at tourists. Never seen them miss. I don't know where that got lost in translation. You know what I mean? Like, they are not new to this. They are not new to this. They are true to this. And maybe that's the key, right? Maybe that's the key. Apparently, it's not like throwing a baseball. Feel like most people can throw a ball with decent accuracy at least, especially under pressure, right? You got one shot, one opportunity, M&M spaghetti on your sweater, okay? Moms, you have one opportunity once you stand up and that bailiff's looking at you like, oh God, you know what I mean? Like, I'm gonna have to tackle this motherfucker. You have about 3 to 5 seconds to get off that throw, okay? You can't do the whole dramatic MLB pitcher wind up where you tap your hat 84 times and do this whole OCD ritual. Like, you just can't. And I would think, I mean, it's someone's situation where you're under pressure that you would lock in some ways. They are never, they're unlocked. They are wide open. They are no cover charge. Come on in. Nothing is held down. Nothing is tight. I will leave you with that. Okay. So if you are indeed the person, if anything, the lesson here is you want to be the person that they're aiming for. You will not be hit. Mark my words. You will not be hit. Back to the case. This is a real quote from a case, a family law case, a judge's opinion that was written in 2010 after several years of a custody/divorce battle. And the judge apparently had enough. Quote, "The parties have repeatedly shown they are immune to reason. Consequently, in my decision, I have tried ridicule as a last resort." I want all of you to listen to this entire court opinion as if we are gossiping, as if you are just getting the dramatic insider tea. We are on FaceTime about somebody else's horrible relationship, marriage, clusterfuck of a life, okay? Pretend we're at the country club with the ladies drinking fresh, crispy cold lemonade on the deck. And we are gabbing about the neighbor girl's clusterfuck of a marriage down the street, okay? That is what will really bring joy to your heart here. Not because people are suffering, but because we're nosy. We're nosy, okay? I'm nosy as a job, for a job. So now we can do it together. Perfect. You can tell by the way the judge is writing this, okay, that they also are feeding into the nosiness, okay? Because maybe they're hoping, hey, if I cast this in the light I actually fucking see it, maybe these two people will act right for a second. They probably didn't, okay? But again, as the judge said, they decided to go with ridicule as their last resort to get these parties to act correctly. So they are indeed ridiculing them and joking the entire way. I really want them to do stand-up comedy. Let's get into it. Judge Joseph Quinn of Ontario, Canada, Superior Court of Justice, Family Court, in his opinion written on November 16th, 2010. That's my friend Lily's birthday. Look at that. Paging Dr. Freud, paging Dr. Freud. This is yet another case that reveals the ineffectiveness of family court in a bitter custody/access dispute, where the parties require therapeutic intervention rather than legal attention. Here, a husband and wife have been marinating in a mutual hatred so intense as to surely amount to a personality disorder requiring treatment. Just right off the bat, guns blazing, okay, guns shooting and blazing. To tell someone, to tell two people that they need to be medically diagnosed, that their pettiness and behavior and loathing and breakup requires a medical diagnosis is so stunning, really. Because in 2010, right, it's not like we're just throwing that stuff around that willy-nilly. Like, this is definitely potentially could get this judge, up for some disciplinary action if they're just calling people mentally ill. You have a personality disorder and you're bipolar and you need therapy and you didn't get enough attention as a child. Like, they can't be throwing these things out just because they don't like somebody. They never had everyone in their mother and the universe in the judicial realm read this opinion and said, you were so real for that. You're right, King. Absolutely. I swear to God. Let's read on. The basis for a judge opening statement, cold open. You have a personality disorder. I would pass away. Paging Dr. Freud is insanity. This sounds like, honest to God, this sounds like an opinion that you guys would probably expect me to write as a joke. Paging Dr. Freud. Immediately, I'm a little concerned. I'm super concerned that there's going to be some mom and son maybe allegations happening. Hating that. I don't think that's what's happening. This judge had to hear evidence, arguments, all of this shit from two self-represented parties. Oh, yeah. They had apparently all of the time in the damn world, time and money in the damn world, to have it be worth it to bitch and moan at each other about who gets what when y'all can't even afford lawyers. And I'm sorry, right? Lawyers are expensive in this day and age. I totally get it. But you have to pick your poison. If you would like to choose petty, you have to either be seeking some money, okay? That fool, that girl or guy or whatever, that they have some money in the bank that you're about to get. They're definitely going to afford a lawyer, okay, kind of thing. And so you're going to be able to pay your lawyer, whatever. Or you have to have money of your own, okay, to be able to say, yeah, no, I can choose petty because I can pay for petty. I've told my clients this before. I'm like, listen, if you want to pay for petty on a losing motion, that's your prerogative, right? All I care about is whether it's legally sound, whether I can legally make this argument and have it at least have some basis, right? Can't be completely frivolous. That's not allowed. These people chose petty without having the purse for it. That is rule number one of Fight Club, okay? You have to pay the cover. And also, if you know you're going to be duking it out with someone you fucking hate, you're going to have a stand-in. You are going to have to Game of Thrones it, okay? You're going to have to call a champion to fight in your favor. The champions being the people who went to school for it, the lawyers, okay? I promise you, whatever outcome you want is going to be better if you have a lawyer to navigate it, okay? And lawyers, especially family law lawyers, it doesn't mean that you can't be petty as you'd like to be. Trust me, some lawyers do some crazy shit for their clients, okay? But I think here it's these people so obviously wanted to just have an arena to shit on each other without really any kind of reasonable probability of a legal outcome being good for either of them. So listen, kids are involved. It's funny, right? It's funny. It is funny, okay? But it's not funny when kids are involved because what the fuck, right? I'm sure that was probably the reason is they maybe they consulted with lawyers and the lawyers were like, well, we could get this drawn up and we could definitely get this resolved quickly. And they were like, immediately, no, I want to suffer we need to be suffering. Okay. All right. Come fucking on, people. Okay. Move on. Stop having children with deadbeats. How about that? Okay. Larry and Catherine married and had 2 children. Larry and Sam were close friends. They work for the same employer. Okay, Larry and Sam, best friends. Larry married Catherine. A few years later, Sam separated from his wife and obtained custody of their 2 young children. Their mother, according to Sam, is not in the picture and has abandoned the children. So, best friend Sam has his 2 children. Larry and Catherine also separated. Larry and Catherine are the subjects of this case, okay? Their children remained with Catherine. Larry and Catherine's children, okay? Sam and his children, Larry's best friend, moved in with Catherine and her children. What is the implication here? They're fucking, okay? They are getting down for the get down. Best friend of Larry is now with his ex-wife, moving in with his ex-wife, separated wife, okay? Crazy. And the children moving in with them is crazy, like one big happy fucking family. At this point, if I were Larry, I'd be like, hi, I am going to actually have a mental breakdown. Maybe I did develop a personality disorder because what is going on, okay? But Larry now has a common law spouse. Larry moved on, okay? Common law spouse meaning there's a woman living with him, okay? Common law spouse, spouses, all right? They are together. That spouse has 3 children. Think about all of the fucking kids that are involved here, okay? Think about all the kids. Larry and Catherine's 2 children are living with Catherine in the house with Sam, the best friend, and his 2 children, okay? 2 young children. 4 kids, 1 house. And then we have another 3 kids in the Larry and other spouse house. Their households, the 2 households, are located 1 mile apart. 1 mile. Quote, in the midst of this social stew, perhaps it is not surprising that Larry and Catherine are having serious problems regarding the custody of and access to their children. The source of the difficulties is hatred, a hardened, harmful, high-octane hatred. At one point in the trial, I asked Catherine, quote, if you could push a button and make Larry disappear from the face of the earth, would you push it? Her I just won a lottery smile implied the answer that I expected. This judge is my favorite person on the planet. Larry and Catherine hate each other, as do Larry and Sam, former BFFs. This hatred has raged unabated since the date of separation. Consequently, the likelihood of an amicable resolution is laughable, hatred devours reason, and a satisfactory legal solution is impossible. Hatred has no legal remedy. Catherine and Larry were married on October 7th, 1995. If only the wedding guests who tinkled their wine glasses as encouragement for the traditional bussing of the bride and groom could see the couple now. I am prepared to certify a class action for the return of all wedding gifts. The parties have 2 children, a daughter, Taylor, born on May 23rd, 1997, now 13 years of age, and a son, Brandon, born on August 28th, 1999, now 11. After a brief split and reconciliation in 2004, the parties separated for the final time on October 1st, 2006, effectively making this an 11-year marriage. They have not yet divorced. It is likely that in the period 2004 to 2006, Larry was having 1 or more extramarital affairs. Interestingly, Larry's father was married 5 times in addition to going through several relationships. Perhaps there is an infidelity gene. Larry, aged 38, is employed as a laborer in the waste management business. He lives with his common-law spouse, Sandra, a personal support worker in a nursing/retirement home. The home in which Larry and Sandra live is jointly owned by the 2 of them. Larry did not reveal this fact in his financial statement filed in these proceedings. Catherine, age 36, is a caretaker with the District School Board of Niagara. In 2008, she commenced a common-law relationship with Sam, who works for the same company as does Larry. Catherine's 76-year-old father lives with them and pays room and board. The next heading of this opinion says, Catherine's genteel family tree. If you don't know, the word genteel means polite, refined, put together. I can only assume this will be sarcasm. Some family trees have more barren branches than others. Larry testified about the many death threats he received from Catherine and members of her family around the time of and in the months following separation. I will mention some of them. In September of 2006, Larry went to live with his father for a couple of days to, quote, clear my head. When he returned to the matrimonial home, the locks had been changed. Larry stated in evidence, Catherine didn't want me on the property and her family threatened to have me killed. I'm saying this with a smile because I think it comes across as funnier when I'm delivering it like I would on a daytime talk show. Selling a used car, right? Larry gave evidence that less than 1 month later, Catherine tried to run over me with a van. Quote, this is always a telltale sign that a husband and wife are drifting apart. King. Larry gave evidence that less than 1 month later, Catherine, quote, tried to run me over with her van. As the judge says, quote, this is always a telltale sign that a husband and wife are drifting apart. On November 21st, 2006, Catherine demanded $400 from Larry, or her brother was, quote, going to get the Hells Angels after me, a motorcycle gang. As the judge comments here, the courtroom energy level in a custody/access dispute spikes quickly when there is evidence that one of the parents has a Hells Angels branch in her family tree. Certainly, my posture improved. Catherine's niece is engaged to a member of the Hells Angels. I take judicial notice of the fact that the Hells Angels Motorcycle Club is a criminal organization and of the fact that the niece has made a poor choice. Is this man still alive? This judge would love the court transcript series. I love him so much. It hurts my heart to know that I cannot have a beer with him expeditiously. Judge Joseph Quinn, do you have an email address? He retired. He retired in 2016. What a king. What a king. Oh, I love him. I hope he's doing well. Alive and well somewhere. If any of you know him in Canada, please, 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 please tell him how much I love him for this opinion. I do not have to add a single thing. This is the easiest episode I've ever recorded in my life. On February 9th, 2007, Catherine told Larry that she wanted him to sign adoption papers so that Sam could adopt their children. When one considers that the parties then had been separated for a mere 4 months, and that Larry was exercising access, this is a remarkable request. What does it tell us about Catherine? You see, I am a woman's apologist. You guys know this about me, okay? I support women's rights and wrongs. I do feel that if we look at the fact that Larold, was cheating so many times over the course of the relationship, as the judge notes, like he was true to this, okay, not new to this. Her having relations with his best friend, getting your lick back, right? Like that is assumption of risk, Larold, okay? Larry, my guy, Larry B. You got to know that your best friend's going to be fair game. Especially when you know your wife, right? Your 11-year marriage type wife. Like no holds barred, right? No holds barred. I'm not saying that this is correct. I'm not saying that what either of them is doing is right. But it shouldn't just be up to the woman to have to maintain decorum when I don't think a woman who has a niece who's married to a Hells Angel was ever planning to be the bigger person. Okay, she was going to be the scarier person, that's for sure. And this shit's diabolical scary, especially considering the fact that Larry and Ben work at the same fucking place. It's really come on. All of you, yes, can stand on your moral high ground, but can we just set them aside for a second? I'm not saying that I would ever condone this, but like, if you heard this, okay, objectively, and like you'd be like, okay, period, queen, like diva, like go off, okay? I do agree with the judge that her saying, hey, so like your best friend's gonna take custody of the children, diabolically crazy. Like that is, she wanted his ass mad. She wanted his ass mad. And Sam has to be in on it. Like it's just a hate, loathing fucking party. I would love to have been a fly on the wall. I want to see every single text message. Like, I am locked the fuck in. I'm locked the fuck in, okay? Remarkable request by her. Very, very bold. But unfortunately, look, shooter's going to shoot. shoot or shoot. All right. God damn it. But like the kids are involved. So fuck. What are you doing? When Catherine told Larry, sign these adoption papers so that Sam can have full custody of the children, Larry said, quote, she threatened me with her brothers and the Hells Angels again. On August 13th, 2007, Catherine's niece, Donna, such a biker girl name, such a biker babe, Hells Angels, old lady name, right? Like you are absolutely running with a biker game. Donna, that is a correct character, like name to face, name to occupation. That's not even judgmental. That's just like I don't know. Like it just, Donna is giving very like with the Hells Angels. Like your name's not going to be, I don't know, Kaylay with EIGH. Like that's not going to be your name. You're going to be a Donna. Okay. It's very strong, very no bullshit, very much a color thigh tattoo. No hate. Like this is not hating. Like this is just like what it's giving. On August 13th, 2007, Catherine's niece, Donna, telephoned Larry, quote, and told me I will get a bullet in my head if I don't sign the adoption papers. She called back later and told me I'm as good as dead. She called a third time to tell me her father and uncles are coming to kill me. Donna is a devotee of the literary device known as, quote, repetition for emphasis. I do not know whether Donna is the niece who is engaged to the Hells Angels member. If she is, they may be more compatible than I initially surmised. Remember when I told you guys like a really long time ago that I am indeed a supporter of women's rights and wrongs? I don't necessarily know at this juncture if that applies in all instances. I think we need to dial it back. We need to dial back. Okay, yes, a man cheating is bad, but the lick has already been gotten back. I know you don't want to have to deal with this guy forever and have him have to raise your kids, but like unfortunately that's the L you take when you have kids with someone that you don't fucking like at all and want to fuck his best friend about. Maybe threatening him with the Hells Angels, like not, it went left. Okay, shit went left. I'm not condoning this. This is not getting your lick back. This is now a crime. The next day, Catherine telephoned Larry and said that she wanted my truck or her brother and the Hells Angels are coming to get it and me. On October 18th, 2007, a nautical theme was added. According to Larry, quote, Donna Taylor, Catherine's sister-in-law, yelled out her window that I was going to be floating in the canal dead. Land and sea, baby, right? Did you guys know that the Hells Angels operate land, sea, maybe even space? We don't know. It's a new military branch we're trying out. I mean, freedom, right? They are a unit. They are a force ready to mobilize when you say the word. Anywhere you need. As can be seen, Catherine and her relatives are one-dimensional problem solvers. The next heading says separation agreement. Because Larry was not making the child support payments required under their separation agreement, of course, they never listen, okay? Pay your fucking child support payments, god damn it, all right? You get next to no sympathy, empathy, bones thrown to you from a judge in a court of law if you don't pay your fucking child support bill, okay? You made the child, you pay for the child. Just because our society puts it on the woman by default to have to fund this shit doesn't mean you're exempt from it. And 90% of the time, anytime a man, the one not paying, the whatever the fuck, okay, tries to get their child support payments, like, I'm going to take you to court to get my child support payments lowered, I've literally seen like 9 times out of 10, they walk out of the courtroom having to pay double. Like the judge is like, wait, we definitely lowballed this. And they increase it. Pay your fucking bills, god damn it. It's your kid. Pissed me off. Because Larry was not making the child support payments required under separation agreement, Catherine filed the agreement with the court for enforcement in December of 2007. Larry has called into question its validity. So yes, that is why in the beginning, the judge was like, yeah, there were a lot of legal questions about the separation agreement. Because, yeah, Larry was violating it. Larry testified that on May 24th, 2007 at 5 p.m., he was returning from his place of employment and received a phone call from Catherine who said that she, quote, needed the papers signed tonight and that he should go to the office of her lawyer. By, quote, papers, Larry understood her to mean a separation agreement. Larry further testified that Catherine advised it would be in his best interests to sign. According to Larry, quote, I felt that if I didn't sign, something was going to get damaged. He did not lay criminal charges arising out of this perceived threat because he, quote, didn't want something to happen to me or my personal property. He's scared of her. I'll give her that. She has achieved that. Larry arrived at the lawyer's office. He was taken into a room with, quote, papers everywhere. Nothing was piled neatly. Mitochondria found in cell. Fork in kitchen. Sink in bathroom. Okay. If your lawyer has absolutely nothing on their desk, it probably means someone else is doing the work for them. They have a different office that maybe is their work office. They're very OCD. They're Patrick Bateman. I jokingly say I would never trust a lawyer that doesn't have their desk like at least with piles of shit, like papers, like things on it. At least like several years in this profession too. But people are probably gonna be like, well, I have never had a shred of dust hit my desk and I'm a partner of whatever. Okay, well, never mind. But trust me when I tell you that is a joke. Like literally like we got stacks of shit. Anyways, he sat at a table and the lawyer was reading parts of the separation agreement to me. Larry testified that he, quote, did not understand some words and asked the lawyer to explain them in layman's terms. Larry signed the separation agreement. It was Larry's evidence that at the time he signed, he was under stress, not only from what Catherine had said in her cell phone call, but from the previous threats by members of her family and from the death of his father, who had passed away 8 months earlier. The judge now mentioned some of the material contents of the separation agreement. Larry acknowledged in the agreement that he, quote, waived his right to independent legal advice. Larry's income. It is stated in the preamble to the separation agreement that at the time, Larry was employed and earning $45,621 annually, and that his income would be lower in 2007 because of a job change. It turned out to be lower by only a few $100s. Custody. Paragraph 7.1 of the separation agreement gives sole custody of the children to Catherine with reasonable access to Larry. Okay, time out. Everyone pause, okay? Do my ears deceive me? I thought that it was Bonkarooski's, Bonnaroo, if you will, that she was saying, hey, so your buddy, best friend Sam is going to be sole custody, is going to be the father of these children, sign these papers now. I thought that this was out of left field. They had a joint. Oh no. He didn't want a damn thing to do with these kids. Okay. I'm back on the wagon of supporting women's wrongs. I still don't think it was correct for the way she did that, right? Threatening Hell's Angels, all that. But like, it's not that fucking crazy that she'd be like, okay, so you already agreed to no custody. So why not just let your best friend have it? But like, that is crazy because like, why the fuck would he agree to that? But you get the point, okay? You get the fucking point. He already didn't want to see his fucking kids, okay? Perfect. Reasonable access to Larry, including a minimum of 2 weeks during the summer. However, paragraph 7.2, which deals with the child tax credit, begins with the words, notwithstanding the fact that the parties have joint custody. Okay, so this lawyer was not great at his job. All right, they were copying and pasting paragraphs, and unfortunately, it was referring to joint custody elsewhere in the agreement, even though in the agreement, Larry's saying, I don't want sole custody. Listen, okay? If you can't afford a lawyer, you should probably get a halfway decent one. No one with a brain was involved here. I believe. I fear. As for child support, the separation agreement provides in part, commencing on April 1st, 2006, and on the first day of each month up to and including March 1st, 2008, Larry shall pay to Catherine for the support of the two children $600 per month. Larry is currently unemployed. Commencing April 1st, 2008, Larry shall pay child support in an amount to be determined pursuant to the federal child support guidelines for the province of Ontario. In the event that on April 1st, 2008, Larry has been underpaying based upon his child support payments of $600, Larry will arrange to bring his child support payments into good standing. It states in the separation agreement that all extraordinary or special expenses shall be shared on a proportionate basis, or as otherwise agreed between the parties, and importantly, that the extraordinary or special expenses shall be discussed between the parties before they are incurred. The separation agreement stipulates that Larry is to pay spousal support for Catherine in the sum of $1 annually, commencing July 1st, 2007, up to and including July 1st, 2010. Catherine is given the right in her sole discretion to commence an application for spousal support on or before July 1st, 2010. So apparently that dollar was just to like hold the place in line, like at a pool table when you throw a quarter down. She was like, I might be game to seek your shit in a min, but yeah. The fact that the separation agreement mentioned that Larry was employed was also an error. He was not employed. He was working unemployed. He was working for a temp service between his employment with 2 waste management companies. So like there are like a fuck ton of dates also that are wrong with this. It's a fucking nightmare, okay? The separation agreement requires Larry to provide Catherine with his income tax returns and notices of assessment for the purposes of determining his child support obligation on an annual basis. Larry never complied with this requirement. Matrimonial home. With respect to the home, the matrimonial home, the home in which you were married in, the home of strife and horror. The separation agreement states that it was appraised at $199,000 and encumbered by a Bank of Montreal mortgage for $163,000. Larry conveyed his interest in the home to Catherine, acknowledging that if the home were to be sold, quote, there would be very little or no equity left to divide. The separation agreement requires Catherine to obtain a new first mortgage, discharge the current mortgage, and save Larry harmless. Larry takes the position in these proceedings that the matrimonial home was significantly undervalued. He feels that a then existing appraisal by the mortgagee would substantiate his belief that the matrimonial home was valued at $225,000. Tellingly, he does not challenge the fairness of releasing his interest in the matrimonial home if the correct appraisal value is $199,000. So it's like, why would Larry have said that even in the event that the house was undervalued at the $199,000? A sale of the house for $199,000 and disposition costs at 6%, the net equity would be $24,000 once the mortgage was paid off, of which Larry would have been entitled to $12,000. But, okay, in response, Catherine says, well, that's why, in consideration of this fact, in the separation agreement, we provided for spousal support of only $1 for up to 3 years. So like, I think that she was trying to say in the agreement, or get Larry to agree to in the agreement, that like between the both of them, like she wouldn't have to pay him shit and he would only have to pay her $1. Like, you know what I mean? Like she wouldn't have to pay him that. I don't fucking know, man. Okay. But that was a weird position to take by Larry, by Larold. It's like, I understand like not everyone's good at math, but like it's 2010. Not 2010. It's like 20 at this point, like 2007, something like that. There are calculator apps on phones. I know there are. The access history. Immediately following the separation of the parties in October of 2006, Larry had access to the children almost every other weekend until sometime in 2007 when it was stopped by Catherine. Access resumed after Larry provided Catherine a check in the sum of $2,500 needed to repair the latter's washing machine and refrigerator. It was the testimony of Catherine that Larry was not consistent with his access to the children, but it is more probable that Catherine interfered with Larry's access at every opportunity, such that any inconsistency was the product of frustration and not disinterest. Okay, Catherine, it's getting hard. It's getting hard to defend you, girl. Access difficulties persisted and temporary orders were required in September and December of 2008 and again in June of 2009. Catherine denied access entirely to Larry from some point in January of 2010 up to the commencement of the 4-month hiatus in the trial. This was a remarkably bold step on her part, taken without reasonable excuse or explanation, because I know people will jump in and be like, what if he was abusive? Like, what if he was this, that, or the other thing to the kids or anything? There isn't like evidence of that. They just fucking hated each other. Hatred does things to people, okay? Or maybe these people were always like that. Who knows? I mean, listen, maybe they are compatible, right? They seem like they are. Most litigants are on their best behavior as their trial approaches. Her conduct reflects the lack of respect she has for the legal system and the utter disregard with which she treats Larry's parental rights. She is a law unto herself. She is also oblivious to her lack of objectivity in matters of access, because she's just saying to the judge, like, well, I don't need to because he's an asshole. It's like, okay, like your thoughts aside, like, you know that he needs to see his kids, like literally, like legally he has to. Oblivious. She's like, no, thank you. So that is the fucking vibe, okay? That's the vibe. Before the commencement of the hiatus, I ordered the parties to meet with Mr. Leduc. Mr. Leduc is the lawyer for the children, because in these types of situations, okay, often a separate lawyer appointed to them, okay? Like some type of advocate, because Lord fucking knows the parents aren't their advocates. They are not sufficient to advocate for them, period. Even in like, oh, like amicable stuff, like the children need to have an advocate. They do in some way, shape, or form, oftentimes. And in Ontario, this was the practice as well. I ordered the parents to meet with Mr. Leduc and come up with an access schedule to cover the period until the child resumed. As a result, Larry began exercising access to Brandon, the child, every second weekend from Saturday at 10 a.m. until Sunday at 6 p.m. Taylor, the other kid, usually accompanied Brandon, but always returned home on Saturday. In other words, she did not stay overnight with Larry and Sandra. During these enforced access visits, Taylor repeatedly said to Larry, quote, "You're not my father. Sam's my father. You're a loser." These are comments that Taylor would have parroted from Caroline, I have no doubt. They are the result of persistent, behind-the-scenes brainwashing by Catherine. So you can tell this judge is like, Catherine is getting in these kids' heads. And this is where it's not funny anymore. Like, shit's not funny, shit's not cool, shit's not kosher. And I'm sure I have listeners who have experienced some type of custody type battles with people where this is literally the result. Or maybe they were kids and involved in this. Like, turning your children against the other parent, no matter how bad that parent is to you. And in this scenario, like, there aren't allegations of abuse. Like, he just sucks, right? Let's say he just sucks. But, like, you are calling the Hell's Angels on him and turning his biological children against him. Like, if he actually is as horrible as you say he is, then you can pray and hope that he'll be a better father than he was a husband, right? And also, in the same vein, it's like, you need to let your children form their own opinions about their parents themselves. Like, you have to. It can only be a negative if you force it on them, like always later in life, especially too. But I mean, clearly, like, this is not healthy in any way, shape, or form. So yeah, at this point, fuck you, Catherine. I haven't really heard anything about Larry yet that would make me hate him. But this case also the judge isn't just railing Catherine in their opener, in their cold open. They were like, both of these bitches have personality disorders. So, we'll have to just buckle up and see. But yeah, this is the point as a family law attorney when I would quite literally lose my shit on people. And I can't do that and still be paid. So I don't. So after this, okay, during this like trial about the separation agreement and the validity of it, both parties are filing several motions on their own. No lawyers involved. Okay. The lawyer who drew up the separation agreement apparently has since bounced. They start filing a bunch of lawyers in relation to, she wants to change access to be more limited and he's not paying his child support. He wants to change access to be less limited. There are all these restrictions, and he wants to also invalidate the agreement because she's claiming that he should get less access because he's not paying his child support in relation to the separation agreement. But he's claiming the separation agreement isn't even valid because he was under duress. You get the fucking picture, okay? The whole fucking kit, can, and caboodle, as I like to say. And the judge has to basically do a timeline of back and forth of these motions, okay? Just bitching. And also, basically both of them saying that Catherine doesn't deserve a support and Larry doesn't deserve a support and Larry's a deadbeat dad and Catherine's brainwashed my kids. You get it, okay? But this is the next occasion. The parties, the judge clarifies, had lawyers for like a little bit of time during the pleading stage. So I actually amend what I said earlier. They had lawyers for a little bit of time when they were like filing all of these motions back and forth prior to trial. But during trial, self-repped. So maybe they were trying to like save a couple bucks. Maybe the lawyers said, we fucking had it. I don't fucking know. Okay. But that's the vibe. This next heading is called Conduct of the Parties and Their Common Law Spouses. It's going to be juicy. On 14 occasions within 18 months, the parties drew the police into their petty disagreements, a sad commentary on their inability to get along and a shocking abuse of the Niagara Regional Police Service. Although the statistic probably sums up all that one needs to know about the parties, I will elaborate for the doubters. A further testament to the hopelessness of the custody/access situation is that the parties and their common law spouses are unable to jointly attend Brandon's ball hockey games without erupting into mutual conflict. This is very stressful for Brandon, the kid, the little kid. Oh, I'm so mad. I mean, it's funny, but it's not funny when the kid is involved. But like the fact that they cannot even attend a fucking like game together, crazy. Larry, we're starting with Larry. Okay, what has Larry done? Larry, and mind you too, this is like, we're starting off already like kind of, I'm leaning. I don't know how about you guys, like let's check in. Okay, let's check in. Let's do like a little heart monitor pulse. What's going on? I'm leaning toward Catherine kind of being the nightmare mostly. Like right now, I don't really have anything about Larry that's negative, except for the fact that he was willing to give up custody of his kids real fucking fast. And he's a serial cheater. But like being a serial cheater doesn't necessarily mean you're not entitled to see your kids. I'll say that. I actually do know people whose dads were serial cheaters and like actually are really great parents. So like, or like was a great parent, just like terrible partner. You never know. But like regardless, it's also like being a cheater is not enough to have your parental custody, like your parental rights taken away. Like parental rights are very strong, as they should be. But we'll keep going. Larry, well, okay, wait. I'm going to clarify that because of recent events. Parental rights are very strong. But the millisecond that domestic violence and abuse and neglect and all that shit comes into play, like if you are a father that is willing to beat on the mother of your child in front of the child, beat on the mother of the child, period, but also in front of the child, yeah, that's when those rights get taken down several fucking notches. Several fucking notches, because that's how people end up dead. Thank you. Larry, who regularly drives by the resident. Oh, fuck. Come on, Larry. We were rooting for you. Larry, who regularly drives by the residence of Sam and Catherine, often shoots the finger at Sam and on about 3 occasions has yelled, "Jackass loser." A finger, the judge says, is worth 1,000 words and therefore is particularly useful should one have a vocabulary of less than 1,000 words. He just called him dumb as fuck. Oh, that's tough. Also, when the operator of a motor vehicle yells jackass at a pedestrian, the jackassedness of the former has been proved, but at that point, it is only an allegation as against the latter. So real, King. In 2007, Larry created a false Facebook account in the name of Catherine, on which he posted derogatory comments that appeared as if they had been authored by her. Facebook is a popular website where one registers and posts personal information, because we had to clarify that in 2010. On August 14, 2007, Larry sent 3 text messages to Catherine within a space of 4 minutes, saying, quote, "The game is just starting. Prepare yourself for a long winding road. Quote, busted. Always look in your rearview mirror." And, quote, "Blood isn't always thicker than water." 2 days later, he texted, quote, "Loser, homewrecker." Not true. The judge says, in recent years, the evidence in family trials typically includes reams of text messages between the parties, helpfully laying bare their true characters. Assessing credibility is not nearly as difficult as it was before the use of emails and text messages became prolific. Parties are not shy about splattering their spleens throughout cyberspace. Splattering their spleens throughout cyberspace. Splattering their spleens. Egg on their face, okay? I so violently concur with this. I thank God for people never shutting the fuck up via text messages, via communication devices. You've seen it in all of these even high-profile trials, like the Karen Reed trial and stuff. Like, you read text messages by and between people, search histories. It's like, that is when people show their faces. And that's why I tell people, even though, you know, it is hard to adhere to, never send a text you wouldn't want to be read aloud in court, because it might be, probably will be, likely, largely, surely, without a doubt. Next, we turn to Sandra's conduct, which is no better. Okay, now, mind you, Sandra is Larry's boo thing, okay, his common law spouse that he's living with. Sandra is a no-nonsense disciplinarian. By the start of the trial, she had seen Taylor infrequently, perhaps only once, but Brandon approximately every other weekend. In September of 2008, Larry was exercising access to Taylor in the home where he and Sandra reside. At one point, Taylor wanted to telephone Catherine. However, Sandra prevented her from doing so, saying, quote, "It's your dad's weekend, not your mother's." See, like, anytime that the third party, right, like the girlfriend or the spouse or the new wife, whatever, gets involved like this, never good. And never prevent a child from calling their parent. Oh, I'm sorry, no matter how much you hate that parent. In February of 2009, Brandon returned home from weekend access with Larry and explained to Catherine that he was, quote, "sick and tired of Sandra always questioning me." Added Brandon, quote, "She asks too many questions about you, Mom." In March of 2009, after another access weekend with Larry, Brandon was angry that Sandra would not allow him to telephone Catherine, quote, "for any reason." Okay, for any reason? Like, come on. The kid needs to be able to call his mom. And I understand that there are exceptions to this, but like, you're also, you know, like, stay in your lane. The court, the judge, I find that Sandra does not exert a positive gravitational pull in this dysfunctional family constellation. Bars. Now for Catherine. The trial began with 3 days of evidence being heard in May of 2010. As it was necessary for the trial to be interrupted by the 4-month hiatus already mentioned, I admonished the parties on a number of matters, one of which was the importance of not denigrating the other in the presence of the children. Yet, in August of 2010, in other words, during the hiatus, which, mind you, the hiatus was put in place by the judge, like, hey, like, okay, pause, because they try to use those hiatuses. How do you plural? What's hiatus plural? Hiatuses. As a way for the parties to kind of take a break, cover their senses, and hopefully reach kind of a settlement or an agreement, or basically come to court less how they were, right? Judges can do this strategically. Sometimes it's like a few days, sometimes a week. And I'm not saying judges in like criminal trials, civil trials necessarily as much. Family law, I could totally see that happening, right? Like people need to cool off, whatever. The judge tries to do that, okay? Usually it's like a couple week hiatus, 4 fucking months. The judge was like, y'all need 4 fucking months of time out to try to figure it the fuck out, okay? And he, in a footnote, says, it is touching how a trial judge can retain his naivete even after 15 years on the bench. He's basically like, I was naive to fucking even think or assume that these batshit insane people would get it together. And obviously, things written on paper are definitely not going to land as hard as watching it all play out over the course of months or years, right? Like as the judge has had to deal with. I so badly want to see what these people look like. I don't know. I need a visual, but I'm not going to search for one. That's for sure. Because, you know, these children are now grown. They're 20 something now, right? Under their 30. Wait, how old would they be? They were like 10 or 11 in 2010. Most of the conduct that was going on that was bad was when they were like 6, 7. Well, not bad, but I guess when it all started. So yeah, they would be 25 now, maybe a little older. Yeah, would love to know their spin and take, but obviously their last names are on blast, and I wouldn't want to expose them any more than they already are with this fucking opinion. So during the hiatus in August of 2010, okay, after the judge said, stop talking shit about each other in front of your children, Taylor was having an access visit with Larry when she received a text message from Catherine that read, quote, is dickhead there? The new shorter Oxford English Dictionary defines dickhead as a stupid person. That would not have been my first guess, says the judge. Bars, bars, bars. God, I love him down. At one point, the children told Larry that if they were to telephone or talk to him, they would, quote, go to jail. Catherine was behind this cruel misinformation. Larry's sister, Suzanne Kelly, whose children attend the same school as do Brandon and Taylor, testified that in February of 2010, while she was waiting to pick up her children from school, Brandon approached her vehicle crying and said, quote, I don't know what to do anymore. My mom won't let me see my father. So sad. In 2009, Taylor told Miss Kelly, quote, I am not allowed to talk to you. And in April of 2010, Brandon told Miss Kelly's daughter that he was not allowed to play with or talk to her. The judge's footnote here, and all of these prohibitions by Catherine are taking place with a trial date already inscribed on her kitchen calendar. Sandra testified that Catherine, quote, gave me the finger while driving on Bunting Road. I am uncertain whether this would be considered a handheld communication device now illegal while operating a motor vehicle under recent amendments to the Highway Traffic Act. Because this is a communication. I want to just have a meal with this judge very badly. I will fly you out. Let's hang out and meet expeditiously, immediately, please. In September of 2008, Taylor told Sandra, quote, you stole my dad from my family, my mom said. Taylor repeated this comment to Sandra during the trial hiatus. Catherine is unable to filter inappropriate thoughts and comments from her conversations with or in front of the children. In fact, she deliberately does otherwise with the hope of alienating at least Taylor from Larry, which, as you guys will find out, worked. She successfully got Taylor to be so alienated from her father that the judge, after like the kids, you know, literally were analyzed and like the kids advocate, you know, talk to them, like it's like very long process of like seeing, you know, what would be in the best interest of the children. The judge did not put in the ultimate custody order that Taylor, like that, like basically Taylor was required to see her father because like of how just bad it was, that like her thoughts and feelings toward her father, never anything positive. Like she had been fully brainwashed by her mom. That was the judge's take. Like literally, like it was just a brainwashing, because like the dad was just not like, they were basically like, dad's a moron, but he's not that, like he's not this. It should not be this bad. Anyways, and now for Sam, the new beau of Catherine and Larry's ex-best friend. Two incidents are representative, in my view, of Sam's nature and character. Firstly, during the trial, Larry passed Sam in the hallway outside the courtroom, and the latter said, quote, "You're done." The footnote says, "It takes a special level of audacity to utter threats under the roof of the courthouse." Secondly, on December 24th, 2007, Larry attended at Catherine's residence bearing gifts for the two children, so like an attended visit. The gifts were refused because, according to Catherine, quote, "Sam doesn't want you giving them anything." Sam's attitude toward Larry undoubtedly has been influenced by Catherine, as Sam has been dining at her table of hatred for more than 3 years. However, this explains, but does not excuse, his deplorable conduct. Miss Katz, the, I guess like child advocate, psychologist, whatever, okay? Like they basically work for like the family services department. And Miss Katz is the one who had meetings and interviews with the parties and children to kind of like give an objective take to the judge of like how the children feel and what's in the best interest of children, okay? Miss Katz confirmed the obvious when she told the court that the children are aware how their parents feel about each other. As for Taylor, okay, so the daughter, Miss Katz sees Taylor as, quote, closely aligned with Catherine. By September of 2010, when the trial resumed, Taylor did not want anything to do with Larry, and she made this clear to Miss Katz. Larry described an incident when, during access with Taylor, he had taken her to a McDonald's restaurant and they were kicked out because Taylor caused a fuss by calling me a deadbeat. This is language that Taylor would have learned from Catherine. On May 23rd, 2009, Larry attended Catherine's residence to pick up the children for an access visit. Brandon said to Larry, quote, "Do you know whose birthday it is?" Larry, caught in an afterthought, answered, "Oh, happy birthday, Taylor." He pulled $50 out of his pocket and told Taylor not to give it to her mother. Taylor was unwilling to accompany Larry because she was having a party with her friends. Larry responded, quote, "No one will probably show." On another occasion, in July of 2009, Larry said to Taylor, quote, "You put shit in this hand and shit in this hand, smack it together, what do you get?" Taylor. What? And the footnote from the court is, "I gather that this is Larry's version of the Big Bang Theory." No, literally. Like, what? What? Larry explained in his evidence that his comments to Taylor were anemic attempts at humor. They were not intended to be hurtful. I accept his evidence. Mr. LeDuc, the advocate for the kids, correctly characterized Larry as a passive man who was not adept at responding to situations involving his post-separation daughter. It is to be remembered that, following separation, Larry was confronted with an angry, hurt, confused, and rebellious daughter who had been receiving advanced animosity tutoring from Catherine. This would be a difficult situation for even the most talented and perceptive of fathers to overcome. Given Larry's near-empty parenting toolbox, it is not surprising that he handled the matter awkwardly. Had Catherine fulfilled her dual parental duty to foster and encourage access between Larry and Taylor, and not to speak disparagingly of him in the presence of Taylor, I am confident that this case would have unfolded differently. Near-empty parenting toolbox. I'm gonna have to reuse that one. I'm sorry. Now we have Brandon, okay, the son. Sam concedes that, quote, Brandon wants to be with his father. Miss Katz explained that in the beginning, Brandon was quite happy to have regular access with his father. However, Brandon has now declared that he wants access on his terms. While having watched how badly his parents botched the matter of access, it is little wonder Brandon feels that he can do a better job. He has said to Miss Katz that he would not mind if access were to occur on alternating weekends or on one weekday and for part of the summer. So the first issue is Catherine's trying to enforce the separation agreement, okay? Trying to enforce it, claiming that he's not making correct payments, yada, yada, yada. And Larry is saying, no, it's not enforceable because I didn't have a lawyer and I was under duress and all of these things, okay? So these are the court's findings, all right? As to that, and I'm not going to get into the legal mumbo jumbo. Sometimes I do. This time I won't because snooze cruise, okay? But the court's findings are succinctly in beautiful bullet points that I love so much, all right? But the court basically said, look, there is no evidence that Larry misunderstood the legal nature of the thing he was signing or its consequences, misunderstood a specific provision. by his own testimony, he said that he had the lawyer read it to him, and then if he didn't understand something, the lawyer would like explain it to him. Okay. He wasn't unaware of what he was getting or what he was giving up. Like there was no like hidden thing. He like had it read to him and he knew what was being given up and all of that. He wasn't rushed or otherwise prevented from reading it at the time. Okay. The Hell's Angels threats are separate. Okay. Separate. Or that he was unaware of its importance or gravity. All right. And in addition, the court makes these findings. Why he allegedly feared reprisals from Catherine's family when the separation agreement was signed, but is not afraid today. So like basically the court found that the repetitive nature of the Hell's Angels threats without any action actually being taken against him kind of meant that they were pretty threadbare. Like he's like, why would signing the separation agreement, like if you were so scared then, why are you not scared now about like slandering everyone on the record and all that shit? Like it just seemed like this was all just shit that you say, right? Like when you're pissed off, like I fucking hate you, you're Debbie Dad, I'm gonna kill you, but like you don't actually mean these things. Yes, they are threats. Like yes, like scary, but like it doesn't rise to the level of actually believing that if you do not sign this contract, you will be like genuinely physically harmed when like that had never happened before. And there was like no reason to believe that they would follow through. Do you see what I'm saying? I know that some people are gonna be like, oh my God, that's crazy, but like I think in this context, it makes sense. And if you read the entire very long opinion, it makes sense. And I'll link it in the show notes. You're welcome. The judge also found that Larry literally chose not to read the agreement start to finish very closely. And he also knew what would happen. Like he knew that he didn't have a lawyer and he knew that he could get one. So I'm not sure what Ontario law says with respect to like separation agreements, certain agreements like this. I know that some states in the US, they're not having a lawyer for one party, or at least like more of an opportunity for that other person to get a lawyer, like would be construed against the other party. But in this instance, after all was said and done, the court was basically like, look, you signed it, no evidence of duress, anything like that. The threats weren't enough. Like, and you know, the lawyer, like competent, explained it to you, and like you could have just walked out. It's the whole thing. So basically, the court decided not to invalidate the separation agreement. However, the court talked about custody, okay? And Larry was seeking joint custody of both Taylor and Brandon. But in his closing argument at trial, he asked for sole custody of Brandon. So to like separate the two siblings. Bizarre. Mr. Leduc, the advocate for the children, was taken aback by this request, calling it unreasonable and not in the best interests of the children who get along well together. I agree. It is disturbing that Larry's judgment is so flawed that he would think it appropriate to split up the children. Larry is thinking only of himself. After more than 2 years of litigation, he still does not grasp the point of this exercise. The children have been in the custody of Catherine since the separation in 2006. It's now 2010. There is no basis upon which the court should consider altering the status quo and separating the children. Like, what the fuck? Okay? So basically, example number 850, why I would just simply never want to be in family law. Is shit like that. You know what I mean? Like, oh my God, get it together. Somebody has to think of the kids. So basically, the court ends up granting a custody schedule that would be enforceable in court as to like an access schedule as to Larry with Brandon, okay, the son. As for Taylor, kind of a bummer, okay, kind of upsetting what kind of happened, all right? Quote, generally, it is unwise to place an immature 13-year-old in charge of her life. Here, however, Catherine and Sam have engineered an alienation that is so complete as to leave the court with no feasible option. I make these findings. 1, the alienation was not present before Larry and Catherine separated. 2, this is not a case where Taylor has weighed the good and bad attributes of her father and found him, on balance, to be parentally deficient. She sees Larry as all bad. There is no ambivalence to her feelings. She is not disguising her true feelings. 3, Larry, although well-intentioned, is an inept father who has not taken steps to identify and fix his shortcomings as a parent. Nevertheless, the utter rejection of him by Taylor is disproportionate, unfair, and unwarranted. 4, As Miss Katz observed, Taylor has aligned herself with Catherine, whose hate for Larry is palpable. The battle lines are clearly drawn, and Taylor knows the side that she wants to be on. 5. I am unable to think of anything that Larry can do to quickly repair the damage in his relationship with Taylor, and if I could, I have doubts that he has the skill sets to pull it off. 6. I did not hear evidence of a single instance of Taylor, since separation, expressing love or affection for Larry. 7. Although children are often required by their parents to do things that they do not want to do, obligating Taylor to visit her father or to engage in counseling is considerably more complicated than insisting that she do her homework or go to the dentist. 8. The history of the parties is such that there is no reason to think they would meaningfully take part in or benefit from therapy or counseling. The court basically demanded and asked that they go to counseling, like separately, not even together. Even before the trial began, years prior, like all of this, like even like the child advocate, the family advocates were like begging them, like, please go to fucking therapy, ignore all requests. They were like, fuck, you know. So like the court's like, it's never gonna fucking happen. Like they're never gonna do this. So what, like literally what the fuck, okay? 9, while it is Catherine's duty to encourage and support a relationship between Taylor and Larry, that duty has been breached too severely to be remedied by the court. 10, it is not realistic to expect that the parties have the incentive and finances to engage in the extensive therapy and counseling that are needed. 11, depriving Catherine of custody, sometimes an appropriate way of dealing with an alienating parent, would not benefit Taylor at this point. It is my view, sadly, that the alienation here is so severe that it is in the best interests of Taylor not to order or enforce access by Larry. If access happens, fine. Without professional help, Larry is incapable of addressing the breakdown in his relationship with Taylor. Although, as I have said, well-intentioned, he is an ineffective parent, and without counseling and other assistance, he will remain ineffective. While Catherine, aided and abetted by Sam, initiated the alienation of father and daughter, Larry has not improved the situation. But I emphasize the fundamental fact that Catherine's conduct is basically the start of the entire alienation, okay? Absent counseling, matters will worsen, not improve. No practical purpose would be served if the court were to decree a schedule of counseling for the parties and the children. The hate and psychological damage that now prevail would require years of comprehensive counseling to undo. Parents piss me off. The legal system does not have the resources to monitor a schedule of counseling, nor should it do so. The function of family court is not to change people, but to dispose of their disputes at a given point in time. I preside over a court, not a church. And despite this knowledge, Catherine has actively sought to create conflict between Taylor and Larry. Larry might consider some common sense steps, such as cards, letters, or gifts, to show that he is receptive to our relationship with Taylor should she have a change of heart. However, he would be wise to have those steps independently vetted by a responsible person, preferably a professional in the child psychology or family counseling field. It is agreed by all that Taylor is immature for her age, and she has been diagnosed with an anxiety disorder. Catherine conceded in deft cross-examination by Mr. Leduc that the conflict in this case is harming Taylor's health. Enforced access would exacerbate the situation. Finally, on this issue, I observed that Taylor calls Sam Dad, whereas Brandon refers to him as Sam. Neither Sam nor Catherine attempted to dissuade Taylor, calling the matter her choice. Yes, the alienation indeed is complete. The separation agreement, therefore, shall be varied so as to be silent regarding access by Larry to Taylor. As I said previously, and perhaps more than once, parties usually are on their best behavior when involved with litigation that is before this court. Here, the parties, especially Catherine, did not allow this more than 2-year case to deter them from their course of conduct. To this day, they think that they are right and everyone else is wrong. A lot of y'all are like that, okay? A lot of y'all. And for the issue of spousal support, after quite a bit of commentary and analysis about Catherine's income and, the income of her new spouse, her new homie Ben, ex-best friend, and Larry's income and all these other factors, final conclusion is this. While Larry's access conduct has largely reflected nothing more than inept parenting, Catherine's parental alienation behavior has been evil. Evil! Imagine a judge just being like, you're fucking evil. Okay, evil. Is there a remedy? Dollars cannot replace the father-daughter relationship that Catherine has destroyed. However, in the circumstances of this case, justice is only a Hobson's choice. Catherine's alienation of Taylor and Larry must be condemned, and an effective method of expressing that condemnation is by way of a reduction in spousal support. Accordingly, the spousal support to which Catherine would otherwise be entitled shall be reduced to $1 monthly. Awesome. Result. Despite the involvement of Niagara Family and Children's Services, Miss Katz, Mr. Leduc, and the court, the parties repeatedly have shown that they are immune to reason. Consequently, in my decision, I have tried ridicule as a last resort. I point out for the benefit of the parties that these proceedings being an effort to vary their separation agreement, I have not changed remainder, blah, blah, blah. It's binding upon them, blah, 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 blah. A final disposition of all these things. A word must be said about the children's lawyer, Mr. Leduc, however, okay? I am indebted to him for his effective questioning of the witnesses and wise and helpful submissions. I expect that this was a trying experience for him. Throughout his year-long involvement in the case, he was contacted on numerous occasions by the parties and by the children. While generally siding with lawyer's position, Mr. Leduc nonetheless conducted himself in a fair-minded manner, impartial to the parties, always alert to the best interests of the children, and in the highest traditions of the office of the children's lawyer. Okay? So, child support is indeed entered. Okay, Larry does have to pay a support. It's back support and then future support. I think it is at 20 grand that he's owing. Okay, spousal support is different. All right, everyone's probably gonna be like, oh my God, spousal support is like support for her, Catherine. No, $1 a month. Child support, I think they ran it at what? $798 monthly for the two children, and then $866 the next year when he made more, and then like $1,100. So that all added up to like about 20 grand that he owed, okay, as of September 2010, and then it would basically continue on this table, all right? So that is just your regular run-of-the-mill, like family custody child support case, okay? Like people are always crazy and insane to very lengthier and more complex and more diabolical degrees. I will admit that, and I will say that. The thing about this is that the judge just took a tactic that I don't think many do, which is to just start joking. Just start chuckling on the record and just making open and honest fun of these people. And I think everyone deserved it all around, because when children are involved, it can only be a sad situation when you act like fucking fools. Okay? You don't have to be perfect parents, but you can, like, it's not that hard to be better than that. I'll tell you that much, all right? My rebuttal for today's episode is be a better parent than the Bruni people, okay? It's not going to be hard to do that, that's for sure. You won't even have to break a sweat. You will simply have to remain cordial with the person who helped bring this child into the world, and without any allegations or proof or evidence or fact of actual physical, emotional, financial, mental child abuse, just plain old ineptness of parenting, just being a deadbeat father who's just kind of awkward and weird and sucks, not a good enough reason to psychologically damage your child. And that might be, right, that might be controversial, but I believe it. That makes sense, because a lot of y'all can't parent for shit. And when I say y'all, I mean a lot of the older generation. That's for fucking sure. But let's break cycles. Okay, people? Thank you. Love you guys. Next episode is coming up very soon. I promise. I know I say that all the time, but we are getting a network, baby. Woo! Love you. Bye. Be safe.